Good evening. This is Making the Case. I'm Yodit Tewolde. We begin with breaking news. The jury in the murder trial of Gregory McMichael, Travis McMichael, and William Bryan is set. But many are already concerned about how the racial makeup will impact this trial, including the prosecution, who challenged the defense's use of their strikes on black potential jurors. Here's what the 12-person jury looks like: 11 whites and 1 black. And while the judge agreed with the prosecution that there appeared to be intentional discrimination during the strike process, he denied the prosecution's challenge. The defense's race-neutral reasons for strikes of potential jurors were justifiable, making it difficult for the judge to discredit their reasonings. Now that jury deselection process is now done, the court plans to take up pending motions tomorrow, which means opening statements are expected to begin on Friday. Here to discuss the latest in court today and the next phase of this trial is Brian Watkins, a criminal defense and civil attorney. Welcome to the show, Brian.
Hey, thank you for having me.
So before I get your thoughts on the jury's racial makeup, let's take a listen to what Wanda Cooper Jones, Ahmaud Arbery's mother, told BNC this evening.
Seeing the African-American jurors come in and they were questioned so harshly by the defense team, and seeing them all struggle, I mean, it was very hard, and it was just, it's like unreal. I mean, I just can't put it into words. I was very shocked that we only had 1 black African-American man. I mean, it's devastating.
Brian, yesterday there were about 13 black prospective jurors in the pool of 65 that advanced to the final stage of this process. Now there's 1 black male on the jury in a trial of 3 white men accused of murdering a black man. Your reaction?
Well, you know, when you're picking a jury, they have to make the jury fair for the defendant, not necessarily the victim. And so it's very difficult to say that a person was kicked by the defense based on his race if they have a good reason other than race to remove him from the jury. You got to understand, with jury selection, it's tough. I mean, we are, as trial lawyers, we're out here using stereotypes and superstition to pick a jury. You got to understand, we're choosing people that are going to decide the case for us without knowing them, you know, and we try to ask them a few questions and try to get to know them, and it's almost impossible. So if they have any race neutral reason why they kicked them, then that kick is valid, you know, and there wasn't, you know, there's not a lot of black jurors, you know, that showed up and that were in the pool in the first place. So I'm not shocked that they ended up with just 1.
Well, the prosecution challenged the defense's move to strike 8 black potential jurors by raising a reverse Batson challenge. For viewers who don't know what that is, in criminal cases, one side in a case challenges the other side's use of strikes of potential jurors on the basis of sex, race, ethnicity, or religion. It's something that's usually raised by the defense against the prosecution, hence the term reverse, because here the prosecution accused the defense of using their 11 peremptory strikes on black potential jurors in a racially discriminatory way. The defense responded saying, quote, "We have a very clear selection process within the defense team, and the issue of race is not one of the factors. I can give you a race neutral reason for any one of these." Brian, the judge said he did in fact find evidence of intentional discrimination during the strike process, but still denied the prosecution's challenge. I hear what you're saying, but you have a judge saying, yeah, I see it, but the statute won't let me do anything about it.
Right. You have to understand that Wheeler v. Batson was the case that's referred to is to protect the defendant, not the victim. It's to protect the defendant from prosecution lawyers using race to kick jurors that could represent and could, you know, basically side with the defendant. So now we have a reverse Batson where the problem is that the defense was able to come up with race neutral reasons. And so we can't say that you're lying. That's not really why you kicked them. You only kicked them because they were black. There's no solid proof or evidence of that. And so with that race neutral reason, the juror gets to stay or the juror gets to go. It's the defense's call. Don't forget, it's the defendant that's on trial here. We're trying to protect his constitutional rights. He's innocent until proven guilty.
But Brian, you only need an inference of proof, right? And when you have a judge saying, yeah, I can see that there could be some merit here with the prosecution's argument, and it's no coincidence that race has been brought up, one, by the defense throughout the entire time during jury selection, and the only person that makes it to the jury is just one black individual. So you can't necessarily, what's the point in having a Batson challenge if you could just make up a race neutral reason and no one can challenge that? I mean, we're not in someone's head.
Exactly, and that was always the problem with the Batson v. Wheeler case, and that's why I was actually on the ballot last year to change that, because we needed to do something. But what could we do? That's true. You're not in someone's head. You don't know why someone's kicking them. And you could kick a jury because they looked at you funny in the hallway. You just got a bad vibe. I mean, because you may have taken their parking spot in the parking lot and saw that as a juror, and now you don't want them on your jury. So it could be any wealth of reasons. And so it's very difficult to prove that it was just race and race only. That's the problem.
Well, another issue Gal raised today was to sever his client's trial from the McMichaels. Gal brought up the alleged misconduct by the former DA, Jackie Johnson, and pointed to what he called antagonism between Brian's counsel and the McMichaels counsel. Now, this seemed like an obvious and reasonable request to make, Brian, by Gal before the start of jury selection, but he's raising the issue after 3 grueling weeks of voir dire. You've got a father-son duo on one side, whose attorneys seem to be working together on strategy to some degree. Then you have Brian on the other side, who told investigators that Travis McMichael used a racial slur after killing Ahmaud. It's in the court's discretion whether to sever Brian's trial, but make the case why all 3 trials should be tried together.
You know, the standard is all defendants accused in one incident should be tried together. That's the standard. There has to be reasons why we shouldn't do that. And so the question is what is the reason why we shouldn't try all these individuals together? Apparently, the defense has not come up with a valid reason that allowed the judge to sever these defendants. They do have a conflict of interest, but of course the prosecution likes that. You know, they want the defendant to turn on each other and say, it wasn't me, it was him. And the other guy say, it wasn't him, it was me. Mm-hmm. You know, that helps the prosecution and hurts the defense. But the bottom line here is the court has to look at whether or not someone will be prejudiced by being tried together. And in this case, the judge found that no one's going to be prejudiced by it. It might not be the best for some of the defendants or that defendant, but he's not going to be substantially prejudiced by it in the event that he will not get a fair trial. He will get a fair trial. All 3 will get a fair trial, and that's what the judge ruled.
Well, the judge is expected to handle outstanding motions tomorrow, then begin opening statements on Friday. Let's talk about the prosecution's case first. What will you be looking for in their case in chief?
The prosecution's case is very, very straightforward. It's basically two-pronged. They had no right to do any sort of citizen's arrest because he did not commit a crime in their presence. That's very straightforward. In order to do a citizen's arrest, the crime has to happen in front of you. You have to witness it. You don't have the ability to do your own CSI investigation, get a suspect, and then go apprehend him. You don't have the right to do that. So step 1 is going to be, I think, very easy for the prosecution to prove. And step 2 is they had no right to imprison him and detain him in any way, shape, or form. They're not police. And step 3 is their detention of him clearly was unreasonable because they had guns. Clearly, it was reasonable for Ahmaud Arbery to use self-defense in order to get this guy who has a gun on him to not shoot him, and you had no reason to shoot him. And so their case is pretty much a 1, 2, 3 slam dunk looking at the video, and I think a lot of the jurors feel the same way. I don't know what the defense is going to put on that we didn't see in that video, but I'm interested to find out.